Hello, everyone. This is another episode of the Unisoft Question, a YouTube show and podcast about lawyers. And today I am honored to welcome a very special guest, Suzan Fraser, a lawyer and a sole practitioner. She founded her firm, I think, more than 21 years ago at this point. And before that, she worked at Swadron Associates, which is a well-known social justice law firm in Toronto. She did some precedent-setting appellant work involving mental health, both civil and criminal, and children's rights at the Court of Appeal for Ontario and the Supreme Court of Canada. For the first 10 years of practice, Suzan also did civil litigation involving police accountability and guardianship issues. Her firm, Fraser Advocacy, is a specialized litigation law firm focused on enhancing the human, civil, and charter rights of vulnerable and marginalized people. She accepts referrals in such areas as mental health, guardianship applications, coroner's inquests, public inquiries, and rights-based advocacy and advice. Those would be the areas of practice of Suzan's firm. She has been counsel in approximately 20 coroner's inquests involving police shootings of racialized persons, persons with mental health problems, deaths in custody, children and youth connected to child welfare, and First Nations adults and youth. Suzan acted as counsel to public interest groups with standing in the inquiry into Pediatric Forensic Pathology, the Goudge Inquiry, the inquiry into the safety and security of long-term care, the Gillese Inquiry, pardon my pronunciation, the National Inquiry into Missing and Murdered Indigenous Women and Girls, where she represented a group of 20 families. She also represents the Coalition for Gun Control at the Mass Casualty Commission in Nova Scotia. From 2008 to 2018, Suzan represented the Ontario Child Advocate, an independent officer of the Legislature of Ontario, at several different proceedings and provided advice to the child advocate. Well, Suzan, this is a fantastic, long list. First of all, hello.
Hello.
I'm very honored to have you here today.
And I'm honored to be here. And I think it's one of the greatest things about the profession is that you and I could be trying to find our way around the Milton Courthouse 10 years ago. And I'm the one who is supposed to have the knowledge. I think you're the one who helped me figure out what to do because you're an articling student. So you were knowing how to get things done. And that, we could maintain, admiration for each other at a distance over the years and end up here. So I'm really, really happy to be here and to have been able to watch you build your own firm and develop this podcast. So thanks so much.
Thank you, Suzan. I really appreciate it. I'm glad I'm still a lawyer 10 years in. And it's true. I vividly remember our first meeting in Milton. It was a small courthouse, and I didn't even know how to draft an order at the time. So that was the situation I found myself in that courtroom. I still remember that. You always remember your early mistakes. And I remember how helpful and kind you were at the time to an articling student. And I'm very thankful to you. And things like that are never forgotten, especially in a hard and stressful profession such as this. So thank you.
You're welcome.
Well, I just read a long list of things that are, I don't want to just call them accomplishments, because I don't think it's just about hitting a target or performance or other things that are often associated with it's not a score, it's not net worth. It's more about a lifestyle, or it's more about a life philosophy, I would say. Doing all the things that you did and still doing them, and doing them consistently for decades, right? So when you do something consistently for decades, I think it just tells us the kind of person you are. So who is Suzan Fraser? I mean, I probably had one or two cases in my entire career in 10 years where I had to deal with people with disability. And those were really difficult experiences for me. I don't know if I can do that. I mean, it's really hard. It's just hard with fully capable clients. It's hard to get instructions sometimes. It's hard to give them legal advice. It's hard to make sure that they understand this terribly complicated legal system that we have. But with people with disabilities, I don't even begin to comprehend. So what sets lawyers like you apart? And why don't we know more about lawyers like you? Why do we keep hearing about these fabulous litigators who work for big companies, and not only, but they all often have very loud and tall voice? But why don't we hear more about people like you, lawyers like you, and who are lawyers like you? Because we don't hear enough about people like you. Tell us who lawyers like you are. What are they all about?
Okay, well, there's a lot in there to unpack, but I think, right from the get-go in law school, you're pointed in a particular direction. And there are law firms that, are sponsoring the back of t-shirts that are taking students out to lunch, that it's like a full court press to get who's considered to be the best and the brightest. And I certainly wouldn't have been considered the best and the brightest. I was, unbeknownst to me, very sick in law school. So I was like definitely middle of the pack. And, I was fortunate to have a good set of articles to be able to sit in on a trial, for 6-week trial. Had a long admin hearings when I articled at Gardner Roberts. But it was pretty clear that to me, and I think to them, that I didn't want to do work that was connected to business. Business didn't really interest me. So that's a bit of a problem in law. If you think that you're going to I didn't want to do criminal litigation because at the time I thought that I couldn't represent people who had offended sexually and committed sexually motivated crimes. Whereas, 25 years down the road, that's a big part of my practice on the mental disorder side. And it's a matter of perspective. So the people who practice social justice, do social justice work, are people who understand that the law and social policy marginalize people. So we talk about vulnerable people and marginalized people, but we have to understand that people are oppressed through law and social policy. So we make policy choices, the opioid crisis being one of them, to criminalize drug use and to police it rather than saying, well, how can we stop people from dying, right? And how can we build a system that will stop people from dying? So these are law and policy choices. So somebody who practices social justice is somebody who sees that there are people who are oppressed, disadvantaged, marginalized, discriminated against, whatever, there's sometimes they're all packed together, and sometimes it's one, but typically there's a recognition that the system doesn't work. And it's not even that it's systemic, but it's actually built in a way that advantages some people to others. And, I don't want to speak for everybody, but for me, I really did go to law school to make a difference. And it just takes a long time to figure out how to do that. And it comes from I have some advantages. I had a roommate until I was like 33. I had parents who were willing to like buy me clothes, because you don't always make a lot of money. Like back when I started at Swadron Associates, I was making $38,000 a year. And the people who were starting first year on Bay Street were making 58. So there was a $20,000 gap on what was not on $38,000. So from the get-go that you're not going to be rich, that you're going to have to be smart, that you may from time to time have to rely on other people. So I've ended up having some good years, some where I've had long proceedings. But a lot of the time it's, willing to live on less so that you can do more for other people. And there's a lot of talk about how hard lawyers work. And yes, we do work really, really hard, but a lot of people have worked a lot harder for a lot less, right? And yes, we do put in those extra 3-4 years of education, but, that's also, supported partially by the state. I know people take on huge debt, but we have advantages, and we'll most likely always be ahead of the national average in terms of income. But it doesn't have to be $1 million a year or $2 million a year. Like I spit out my coffee when there was a story about there being a $200,000 pay gap between men and women, because most social justice lawyers would never achieve $200,000 a year, right? And a lot of sole practitioners won't either. So you just have to say what's important to me, and how can I build support around me to make this happen?
Well, from the practice management perspective, I have a question about funding social justice law firms. I just want to jump right into the nitty-gritty of social justice practice. We know that this is a very private sector driven society. Even Canada, even compared to the US, when we say that Canada has a bigger public sector, it's still a very private sector driven society. The participation in the court system requires a lot of money. How are social justice law firms funded? I assume that most of their clients are indigent. People with mental health issues, people with disabilities, people who cannot speak for themselves. You help the oppressed, you help the poor. Who is paying for all of that? How do you raise money to pay for all of that? This is such an important function in society. How is this function supported? How does this society support this function, representing all of these voices?
So when I started, so much of that work was funded through Legal Aid Ontario. So Legal Aid Ontario used to have civil law funding, which is now, I think, pretty much been reduced to disbursements in sexual assault cases. But it would fund novel pieces of litigation. It funded family law. It funded, so I would do test cases, and I would represent people in civil actions if they didn't. And so through funding of discoveries until about 1998, I think. So in the very early years of my practice, there was funding for civil litigation. There was also test case funding through Legal Aid Ontario to bring a test case or to represent people at coroner's inquests. So some of those early coroner's inquests, Legal Aid Ontario might have funded the family, and they might have funded two different groups. So for example, the Queen Street Patients Council, when I represented them, that was funded through Legal Aid Ontario. So really supported through that Legal Aid's mandate and law reform. So the second, so that's like the bigger pieces. The public inquiry system in Canada does have funding for parties with standing or participants. So typically in one of those big proceedings, you'll have state agencies represented. So for example, in the Goudge Inquiry, you had the coroner's office was represented. There was, they had their own funding. They had Dr. Smith would have been represented through CMPA, but there were other people like the Association in Defense of Wrongfully Convicted, the Criminal Lawyers Association. I represented a children's rights organization, and we applied to be recommended for funding. And then there's a funding, then if you're granted funding, which is sort of on the basis of not being able to participate unless you're funded, then you're actually funded. So, in 2007, when I did the Goudge Inquiry, that rate was $192 an hour. So that was, pretty decent money. That rate hasn't changed. So when I did the Gillese Inquiry in 2018, the highest rate, so for 10 years plus, is $192 an hour. So that's the nitty gritty. So there's funding. And then, I do a lot of work for people who are in institutions. And everybody says, well, how do you get instructions? And most people are able to tell you what they want to happen with their life, right? So, and so you support that decision-making. You are able to help them guide through, and there's challenges. I think I was once told that the average person takes 7 times either hearing something, speaking something, writing it down, or reading it before they learn it and understand it. But a person with a developmental delay takes 200 times. So that's the way it was explained to me, whether that's actually true or not, but it's certainly time. And that becomes constraining. So for example, a consent and capacity board hearing, where somebody's right to refuse treatment or consent to treatment is at stake. Just take that as one example of what you might do at a consent and capacity board hearing. Another example might be whether they should be detained as an involuntary patient. That takes legal aid's tariff of preparation will give you 10 hours. So you have 10 hours to read thousands of clinical records, meet with your client, understand their perspective, maybe seek out collateral information to help defend their position, research novel points of law, if there are, all of that, 10 hours preparation, and then your hearing time. And then if you go over that, you can ask for what's called discretion. So you have to set out your case as to why you should be paid. So you get talented at, I have an assistant who's, really able to explain to the legal accounts officers what we've done and why it matters to the client, and that, so that you can actually get paid. Doesn't always happen. Sometimes your accounts are cut back. It's really hard to do work within the tariff. So it's financially, you have to be smart. And I haven't always been, I've always had an office. And I've always had an assistant, sometimes part-time, sometimes full-time when I've been really busy. But that's a lot of money that you have to earn before you get paid. And if you're only making, I'm getting the top legal aid rate, which is $136 an hour. That hasn't changed since 2015. It takes a long time to actually earn money. And in a practice like this, you really need to have a safe space to go to, and an assistant to help you, and even just for moral support, right? So I'm in a chambers arrangement right now, which is quite excellent, although I don't get to spend a lot of time there right now.
Knowing even the little that I know about the situation of people with mental health issues, about the situation of people with capacity issues, I'm terrified. I'm terrified when I deal with fully capable people who find themselves engaged in issues with the justice system, and even in civil litigation, commercial litigation. I'm terrified for them. I'm terrified for some of my clients because it's extremely hard, even when you're fully represented, even when you have full resources and full capacity. This is extremely hard to deal with some issues when you're a participant in a proceeding because of the stakes, because of harsh consequences of mistakes. But now when I think about people with restricted, limited capacity, who are also systemically oppressed and otherwise vulnerable, I'm terrified. So my question is, has the system for them, the system that is meant to protect their rights, the system that is meant to provide them with justice, has that system already fallen apart? And you're just there picking up the pieces and helping out the lucky few who find you? Or does the system still work? And maybe because of people like you, maybe because of others.
So it's really, I think there's a great sense of injustice for people who are appearing before administrative tribunals. So largely in this area, so if you're talking about some of the mental health issues, I think largely people feel that they really can't understand administrative efficiency. So there's a great push both in the Ontario Review Board and the Consent and Capacity Board to have hearings done within 2 hours or an hour and a half. So, and typically people are faced with a big report that comes from the hospital. And it's hard even to carve out more time. So it's a challenge to say, I'm going to need more than 2 hours. There's a lot of pushback from tribunals to do that. So even that's a victory. But I think you have to and there's a danger, I think sometimes, you know, there were a couple hearings this year where I thought, am I doing more harm and good than appearing in a tribunal that didn't particularly feel good and felt like a rubber stamp? So, you know, and I think that that's the lawyer's challenge, is to make sure, so it requires constant vigilance to, you know, get your elbows up and, you know, work those corners to be able to fend people off. So there, I think there's a great sense of injustice, and I think there's a great I think that the accessibility to the charter is a challenge, right? That, you know, our system in Ontario of Rule 14 applications and affidavit evidence and all of that stuff, where the person, you know, I would like to see Ontario move to the Joe Arvey model, where they have, in BC, they had a trial, you know, where the Carter case was a trial where he could call witnesses about the impact of, you know, not being able to plan for the end of your life and to have medical assistance in dying. And I think that there's some things that we could do much differently here to provide better access to justice that way. But I have many clients who've been in the system for a very long period of time in the forensic mental health system, where if they had pleaded guilty, they would be out otherwise. So it's really hard because we have this responsibility to uphold the administration of justice, right? And I think that doesn't mean that we can't be critical, but that criticism has to be, you have to, if you're going to be critical, then you have to tell it to the tribunal, right? You've got an obligation to say this process isn't fair. So we all feel that unfairness sometimes. And, you know, I think we all have our greatest day is when we go into court and we are heard, right? So when the client feels heard and the decision goes the other way, most of the time my clients are okay with that, but it's where they feel that they haven't been heard, or where they, you know, They feel that there's a bias that you can't quite put your finger on. That becomes harder to swallow. And then there's just people who are a long way from justice, right? You know, when I did the work before the National Inquiry, like people whose family members haven't come home, and family members who haven't come home, and maybe they would know where their family members were if there had been a better police investigation. And like, what does justice look like? It doesn't, you know, when the system is so so discriminatory, and where, you know, it's pretty clear now that there's, not pretty clear, like, but you've had the Truth and Reconciliation Commission saying cultural genocide, missing and murdered Indigenous women and girls saying that Canada, that these deaths have occurred as a result of a genocide. We now have evidence of crimes against humanity in the form of unmarked graves at residential schools. You know, I think there's a great deal of us living with a tremendous sense of injustice. So you can be defeated by that, or you can go on, and you kind of have to choose what you're going to do. For people in the mental health system, a lot of times they do better if they submit, right? If they just say, okay, just like whatever, I'll take your medication, I'll follow your rules, I'll do whatever you say. And the people who fight the most end up being in the system a lot longer, and people who've, you know, retained their internal dignity and advocated for their rights and never succumbed end up being in the system for a long time, and that's really, really difficult. So being a social justice lawyer is living with a lot of defeats, living with a lot of unease, and finding a way to go forward.
Speaking of getting your day in court being heard, I know that you've done quite a few trials in the course of your career. Can you speak, please, about the trials that you did? What types of trials, what types of cases resulted in trials? Your trial experience. Would love to hear some more details about that, please.
The first trial I did was the one I was an articling student, which was before Justice Feldman, and it was a 6-week trial that seemed like turned into a 3-month trial, and it was about less than truckload freight. So there was a plan to deal with less than truckload freight. And really kind of interesting now, considering where we're at with Amazon and how parcels get delivered and everything. But it was great because there was tons of, you know, there were expert evidence, forensic accountants, damages claims, challenges to witnesses. And you got to see, you know, you were preparing all these memos in advance for the lawyer. And then you got to see why the lawyer had done all this work in advance, right? So it wasn't about the issue may never arise, but if it did, you were ready. So that was great preparation for me. And then when I did a very long case that went on for months. And it was, I'm not going to talk about the details of the case because the client would like to be forgotten. So, but this case involved, you know, people on the other side who were represented by Law Pro and all kinds of things. And so it was, first of all, a lesson in the rules of civil procedure. I mean, we really hadn't, it was complicated and there were challenges. And I think that, you know, we could have come about it at a different way in retrospect. But it was, you know, watching sophisticated counsel do a trial. So it was excellent. There were 3 parties. But where I learned the most is in the coroner's inquest, because the coroner's inquest, the first inquest I did, the inquest into the death of Edmund Yu, there were 10 counsel. So lawyers for the police, Frank Morocco was there, now retired Associate Chief Justice Morocco was there, sitting beside me, representing the Chief of Police of Toronto. Julian Faulkner, Richard Macklin, Louis Sokolov, Janice Blackburn was there for the Ministry of Health. So tons of excellent lawyers. And the trials that you do, I think, are really only different. It's really about evidentiary standard, right? So in trials, there's a more formal application of the rules of evidence. In a coroner's inquest and in public inquiries and administrative tribunals, those rules are relaxed. So you're not always worried about tripping over the rules, but at the same time, the rules of evidence matter because you want to make objections about the quality of evidence, things like that. So the other trials that I did, the police accountability trials, I did a couple of trials where different, one was a witness protection trial. So the person had been promised witness protection. And she had been a witness at the David Milgaard Supreme Court of Canada hearings, and she had been promised witness protection, which Chief Justice Lemaire phrased as police witness protection. And then there was a debate about what that looked like. And so she ultimately sued. We lost that trial, but it was all, again, very, very interesting. One case that I still can't fathom that I lost is a case where a woman had been detained she was in a police holding cell, and she had faked a suicide attempt. And so when the police officers responded, they took her clothing and they shackled her to the police cell. And it was a mixed result. And then there was an appeal to the divisional court that was done by somebody. Anyway, like sometimes, and I just think that case would be decided differently today. So we've benefited so much. You know, what's changed dramatically for me in the last 25 years is that I think there's an acceptance now that police are not always acting appropriately. We have seen the evidence of that, plain and simple, in the last year. I mean, I didn't watch the video of George Floyd, but you know, people witnessed a murder. People woke up one morning, turned on their phones and witnessed a murder. And you know, that's going to take a toll on everybody, especially people who are racialized and have been the experience of police brutality or oppression. But I don't think that people understand that 25 years ago, to call out police conduct, you would have been, you know, you were really sidelined for doing that. So Barry did some other cases. So some of those I did on my own. There was another police witness protection case. But slowly, like it was just such an uphill battle, and the costs were really escalating, and I wasn't winning. So I just thought, like, this is not. I feel like I'm doing a great job, but I'm not winning. And is it? Do I? You know, somebody else maybe can win, but it's not me, and I'm not going to take these clients down this road that feels like it's and up where the playing field wasn't quite level. So now I think a lot of those cases maybe would settle. Maybe I would have pushed in some of those cases. Maybe you can push a bit harder for settlement. You know, I was very much of the view that justice would prevail. And now I'm much more cautious about you know, how to get a result. And so a lot of advocacy is about what's the, you know, outside of the courtroom, what's the result that we can achieve. But that doesn't always advance the law, right? So all these things getting settled in the background don't necessarily advance the law, and that's the challenge. And I think, you know, as proceedings settle and we don't have access to trials, I think we risk the law not developing.
You talked about that police misconduct case where a woman was shackled in her cell, and you said that that case would probably be decided differently today. What would be different today? What will be different today? We assume that the evidence is the same. So on the same evidence, why would the court decide this case differently? Because the law has changed, because judges' interpretation of the law has changed. And why, if it has, then why has the judge's interpretation of the law has changed, and how it has changed? Or is it just the human element in judging, in adjudication, that has changed? That vague, imperceptible, undefinable human element has changed, where the judges look at the same things differently now.
I think it's the latter. I think that judges are shaped by their experiences. So what falls within the range of experience, I mean, it's why diversity on the bench is important, not all kinds of diversity. It's why it's important to have criminal lawyers, defense lawyers appointed to the bench. It's why, you know, it's important for people from different communities, different frames of being, to say, you know, our common experience isn't this Anglo, WASPy, like there's a broader range of human experience that I think the more that the bench becomes diverse, and that the more that the common experiences, you know, we just share so much information about what's happening to communities now. You have direct evidence on a daily basis about what is prevalent and what's not prevalent. And that does shape the thinking, I think. So, you know, I always think that in order to make, like when you look at where change really happened, so for example, same-sex marriage, by the time that case was decided, there was a critical mass in the community of people being out, of family members having somebody in their family who was from the LGBTQ community. And so it was like, of course my child should get married. And it had become within the understanding of the judiciary that this was about humanity and dignity, that it sort of became obvious that that case should be decided that way. You know, look 10 years before that, where people were talking about putting same-sex marriage into law through the legislature, and that wasn't it. There was way more blowback to it. So things change, but they change because, like, you've got the masses, you've got the media, and then you've got the message. So, but you really, like, in order for that message to carry, to change the law, the public has to come along with it, which I think is why when people have novel cases, that it is important for the media to take those up, to examine them, for people to be able to, like, for that to become part of the public discourse, so that the judiciary, you know, they read the Globe and Mail, they read the Toronto Star, they watch the news, like, what are people talking about? And it's important that, you know, so when I say that case would be decided differently, I think maybe that's too optimistic, but what I think would be different is that there would be more understanding that when police act, it's not always for benevolent means. It's not always to serve and protect, and that for some people it actually seems to be quite the opposite, right?
Yes, I'm always curious about this magical element of adjudication, the application of the law to the facts. I think this is where the magic happens. And this is also the least definable, the least predictable the most amorphous and the most human element of adjudication. So to me, it's the most fascinating element of adjudication and my work as an advocate. So how do we train young advocate about that element if it's not even defined in reasons, if it's not even expressed in reasons, often in reasons for decisions, in cases, if it's not written down, if it's not recorded? I don't think that judges often admit in their reasons, well, I don't think police ever makes mistakes, right? I think police is a state institution and we should just trust it. I don't think they said that before when they found for the police, right? They never said that before. But now for some reason, they make different decisions, but yet I don't think they still say that, well, police is fallible. I don't think they really say that. I don't think that those perceptions find their way into the written reasons, and it is the written reasons for decisions that we use to train advocates. And you mentioned community standards as a source of judicial decision-making. At least I call them community standards. When you talked about family members being recognized by their own families, and eventually that's seeping into the judiciary. So how do we train young advocates about all these different sources of judicial decision-making that are unspoken or unwritten, and that often are really the thing that decides the case?
So I think that, it's not, I don't really know how the sausage gets made, right? So I'm interested in reading Justice Sharp's book because I think it provides us a really good tool for, for somebody like Justice Sharp, who was he wrote this book called Good Judgment that came out this year or last year. And I'll lend it to you if you want it. But really talks about trying to stay within decided law and trying to be really disciplined. And I think most judges do want to say that the law is neutral, right? And that we are applying facts to a neutral law. So if you're trying to move the needle, and I think for most cases, that's how most judges would frame it. So the lessons that were taught to me were that if your client's experience is outside of the norm of a judicial experience, right? So, for example, if I was doing a case about you, okay, what is it like for a person who was born in Uzbekistan, who lived, and I only know this because I watched it when Neha turned the tables on you, which I didn't know about when I said I offered to turn the tables on you. Anyway, so I watched her interview. And so what's that experience like, right? So your job as an advocate is to explain and to educate what the experience is. So you can't just do it by saying, police are bad. So you actually have to have, so sometimes it might be like getting a criminologist to talk about racial profiling and to talk about those experiences, and that, if you want to make a case, so it's about sort of trying to figure out how to build some education in. Sonia Lawrence, Dr. Lawrence, who's a prof at Osgoode, has written about judicial diversity, and her argument, I'm not going to do justice to it, but really is that like the more people it's almost like going to a party, like the more people that you meet at a party, the more you realize how like different people are in this world, right? Just what you're doing with your podcast here is all these different areas of practice that people don't know about, and so that expands our notion of the world. So it's not necessarily, it may not necessarily be the judge bringing their own personal experience, like especially from somebody who's from a racialized community, but it may be that when there's a judicial mix, that expands the thinking. So in terms of teaching young advocates, I think always educating, always, like for me, it's always having the panel, and especially for people who are suffering in institutions and who have been sidelined or not making progress, to have the adjudicators understand the humanity of the situation. Because when you have a client who is the subject of any system, that's one level of dehumanization. They're already a subject of something. And so your job is to humanize. And if you can know your client and humanize your client, understand that experience, then you have to translate that for the judge. And so if you're in a case where you think, the judge isn't going to have a good understanding of what it's like, your job is to paint that picture. And that's what we are. We're storytellers, right? So that's the advocate's challenge, I think, is to tell that story and to paint that picture and to bring as much common humanity and understanding so that their client's perspective is well understood. And it's not always easy.
Yes, it's not always easy. I thank you for this lesson. This is a lesson that I keep trying to teach myself. I didn't know this in the beginning of my career as an advocate. I came from a background that was pretty so technical, or I would say simplistic, that didn't have much of a human element. I was a computer programmer before law school, and it's a double-edged sword, because on one hand, it makes you very analytical. On the other hand, it makes you a little bit dumb, because you just are too straightforward. You just take things at face value too much when you deal with machines and computers and computer code all the time. And it took me a few years of practice to realize that we're not dealing with algorithms. It's not just about straightforward application of the law or formulas. There are no formulas, almost no formulas. I recently posted on Twitter about bright line rules. There was a Court of Appeal decision where the Court of Appeal upheld a professional college's decision to take a license from a dental professional who treated his wife. So, and the argument was, well, this is absurd. No, the Court of Appeal said it's in the statute. It's a bright line rule. We don't want to argue about different cases. You cross the line, you cross the line. So there are formulas, apparently. There are formulas, but I don't think there are a lot of formulas in law and in practice. And I really thank you for reiterating this lesson, that there are not a lot of formulas, especially I would argue with vulnerable populations. There are not a lot of formulas, because mental illness is a spectrum itself. And vulnerability is a spectrum. So how do you draw bright lines or red lines in that? It's really impossible, in my opinion. I really thank you for this conversation, Suzan. I don't want to end on a note of me giving a lecture here and sharing my opinion. So I want to talk very briefly about your origins, because I'm sure our audiences are interested in where you came from and how you grow up to be a lawyer like you. Where were you born?
I was born in Trois-Rivières.
Oh,
So
are you from Quebec?
Well, my father, I was born there and I lived there for a while. And my family has spent quite a bit of time there in my upbringing. My dad was a civil engineer in what I call the golden age of civil engineering. So he built, there's a bridge in Trois-Rivières. If you haven't been over it, it's quite spectacular. It's a 2-mile bridge over the St. Lawrence River. And, when you talk about hard jobs, when people built that bridge, they were working in compressed air under the icy St. Lawrence. And there was a collapse and several men died. Luckily, my father was not one of them. And so we lived there. My mom learned French. She raised their, I had an older sister at the time. But we moved around quite a bit. So we moved from there to my dad building a bridge in Ottawa, to then there was another place. When I was 4 and 5, we lived in Welland, Ontario. So my dad was working on the East Main Tunnel, which is a tunnel that goes under the Welland Canal. So prior to that, there'd been a series of lift bridges, and this tunnel was going to replace one of the lift bridges. So that's a pretty cool thing, to be able to walk under a river or a canal when you're 5. Like so my dad would always take us to the job site, and I can almost smell the concrete. And then we moved when I was entering grade 1. We moved to Thornhill, and I lived there until I went to university. So pretty cushy. And my mom started teaching when I was in grade 3. So it became a 2-income family, which meant that we could take a vacation to Quebec and go skiing, which was pretty cool. And it was a pretty nice existence, My parents don't live there anymore. And then I went to Hamilton for university, which I, like, it was love at first sight when I saw the McMaster campus. And then I stayed there for 5 years because I did 1 year full-time student politics. And then I went to Western, and it was like, that was a really hard, going to law school was really hard. Like finding your voice in the law and like a place where you belong, I think is really hard. And, early 90s, there was a huge recession. They called it the Great Recession, biggest recession since the Great Depression, almost a depression. So, I was lucky to have a good articling job, and I was lucky to get great experience there, but there weren't a lot of jobs when I graduated. So I was happy to connect with squadrons who I knew Marshall from high school. So my privilege definitely allowed me to get a connection there. And it just kind of shows you that the advantage that people who have been settled here for a long time have. So that's how I got to where I'm at. But really, like, in terms of influences, I had lots of family influences. My granny was an Irish immigrant and had witnessed a lot of police brutality. So she instilled in me that, don't always believe what you hear the first time, and there's 2 sides to a story, and police aren't always angels. So that kind of stuck with me, like having her recount that still stays with me. And then my mom was always, like in the way that a white woman does in the 70s. There were certain foods that we couldn't buy because they didn't pay women equal wages. Right. So and my father, because he's an engineer, he takes his social responsibility very seriously in terms of his obligation to protect the public. He's not now retired now, but watching him and the care that he took and the understanding and watching somebody think in a different way. So he's, he closes his eyes and he can turn an object in his head and see how it's all going to work. Right. So just a different way of thinking. And so that's where I came from, born in Trois-Rivières, and then moving on to, that's pretty much as close to Toronto as you can get without being in Toronto.
Thank you, Susan. I'm thankful for this opportunity to talk to you. I'm thankful for having met you 10 years ago. I'm thankful for our ability to keep connected throughout this time. Thank you so much.
Thanks so much for having me. It's really a pleasure to be here with you and to be able to answer some questions and to see you and wish you well coming out of all of this. And I hope that you keep going with the podcast because I think it's great.
Thank you.